All right, there we are. Hello, everyone, and welcome to today's webinar, How to Engage with Your General Counsel with Eileen Akins and Tommy Brooks. I'm Kaylee Bonson, and I'm the SBAO. I'll be monitoring things for you guys today. So if you have questions, please enter those into the Q&A box right there on the right-hand side of your screen. And once those come in, I'll read those out. Otherwise, I'm going to pass it on over to Eileen and Tommy.
Thank you. Tommy, want me to sort of get this started by way of general introduction?
Sounds good.
Hi, everybody. Thanks for being here. I'm Eileen Akins, as Kaylee said. Tommy Brooks is here. I have my firm, the Northwest Local Government Legal Advisors, LLC, and Tommy is with the firm of Cable Houston, and both of us provide general counsel to local governments, whether they're special districts or cities or sometimes counties. So we have a very similar practice area, and so decided that we might be helpful in this conversation today. And I think that Tommy and I have a couple of topics we've talked about, well, a short list of topics that we thought we could talk about, but we're also open to having you guys get your questions answered. So as we go, Kaylee is going to pop up and tell us if any of you have questions, so feel free to ask them. So with that said, anything you want to add to that, Tommy, by way of introduction?
No, just by all means, ask questions. It'll be more fun to be engaged with the dialogue than it is to drone on to a screen. So please pipe in when you want to.
Fair enough. The first thing we thought we would talk about is for us as general counsel, we provide general counsel to the entity. So whether that's the special district or the city or the county, that is a legal entity in its own right. And so in that role, our client is the entity, but because the entity doesn't speak or act, we represent the board. So our client, for purposes of representing local governments, is either the board of directors or the city council or the county commission. Sometimes the question will come up from clients, employees sometimes will call and want advice about their employment situation. And we would have to say, we can't advise employees specifically, we have to advise the board. And there's, in our experience, some better ways to set up that relationship in order to manage that process. Do you want to speak to that, Tommy? How to arrange for who contacts the lawyer?
Yeah, and for a little bit of context too, this isn't just a practical thing. There's an intersection here with our rules of professional conduct that govern attorneys. And whenever you represent an entity, you still have to figure out, entities are always speak through people. And our rules of professional conduct recognize that. So the structure that's sort of put into place is that you represent the entity and you communicate with what's called a duly authorized constituent, which is a mouthful and definitely a term an attorney came up with. But I think it's a really important thing to identify who those duly authorized constituents are. So one of the practices I've been implementing more recently is having our clients in their board policies, whether it's a board governance policy or kind of your bylaws document, whatever you use, is to be very express about who those duly authorized constituents are. And it's easiest to make that two people. One is usually the chief executive, if it's a general manager, executive director, that kind of person, and then the chair of the board. Obviously the first, because most of the day-to-day work of the entity happens through your chief executive. But sometimes you do need to communicate with the board. Sometimes maybe the issue is about the chief executive, or maybe they're just not there. But you don't want to obviously communicate with the whole board all the time, because then you're talking about public meetings laws and everything. So to identify the board chair or someone on the board who has that authority to talk directly to the attorney, it sets up those two lines of communication, which I think has been pretty useful. And my last point about that is the reason to put that into your bylaws or whatever your governing documents are, is to establish that relationship when times are good, so that if times are bad, you don't have to worry about who's authorized to do it. You look back, you've got your policy, and you know who you can talk to.
And that has some very practical, in addition to kind of the streamlining the contacts, it also has some very practical benefits, in part, which impact the district's bottom line or the entity's bottom line, and that is we're gonna kind of morph into some other ways to work efficiently with council. But we both had the experience of, because board members, are 5 or 7 or sometimes 3 or more. We have had the experience of being, when the board is in disagreement or in conflict, it's not unusual for individual board members to want to talk to the lawyer to try to get, see which side we're on. And that not only is very, makes it very difficult for the lawyer to advise, it also drives up your legal costs significantly, because then the lawyer is talking to all these and basically playing referee between all these people who have a take on the situation. So in terms of managing the board, being clear on who is going to be contacting the attorney ensures that the board needs to work collectively and decide as best it can, at least a majority have to agree when legal advice is necessary and how to follow it. But when you have multiple people who all want the attorney's ear, it makes it very difficult to be the attorney, but also it makes it very inefficient and expensive for you guys to do your business as well.
And I would echo that part too, about sort of the efficiency of it, because I'm not going to decline a call from a board member. I think it's part of the customer service, but once that conversation happens, then you feel compelled to make sure that you've had that same conversation with everybody, or you at least brought it to the board. So you end up having the conversation multiple times anyway. So the more you can streamline it on the front end, I think the less your costs are going to be.
Agreed with that. And feel free to ask questions as we go. We had also talked, because we kind of started it on that topic, in terms of how to use your attorney's time efficiently. One of the other things that when Tommy and I were comparing notes about things that particularly seem to be coming up lately is in the area of contracts. I have had several clients who want us to provide it comes about in a couple of ways. One is they want a template contract that they can then use indefinitely, presumably for any reason, which we could talk about. And then the other related thing is clients who either prepare your own contracts or borrow other people's contracts and send them for review and comment. In terms of the template question, I mean, understanding the fact that a lot of the times you guys are doing contracts that are very similar in nature, like you might do the same thing, like liability waivers are an example of something that might lend itself to a template format, because you might be doing certain activities and you need people to sign forms and so on. Those are going to be fairly standard depending on the activity that you're doing. But contracts are not one size fits all. What goes into a contract or what needs to be in a contract is going to vary widely depending on what it's for and how big it is, and to what extent it has to comply with the public contracting laws, et cetera. So the concern as attorneys is that when clients want a template, a lot of times what they're looking for, in my experience, is kind of a fill in the blank form. Like, we don't want to have to go to the lawyer every time we need a contract. We want something we can just use for whenever we need a contract. And that can get the client in trouble quickly. Unless you have experience in reading and interpreting and writing contracts, there may be things inherently in the contract that are either not right. I've drawn the comparison particularly when you use somebody else's contract, it's like using somebody else's medication. Like, it wasn't designed for you, and it might be fine, but it also might kill you. So when you think about the contract form, they are not one size fits all. And a template contract, understanding you might want a basic starting point, but I always encourage my clients, if I provide kind of a form for them to work with, is get back to me before you actually implement it and tell me what you're going to use it for, just so that I can make sure that it doesn't get you in trouble. And that's a really good way to use your attorney time ahead of time, rather than ending up with a contract that you're going to end up in some kind of dispute, and then it's going to cost you a lot more money to get your attorney to help sort that out.
And my take on it is very similar. When we think of public procurement, there's these big categories, right? You've got your, goods and services, you've got professional services or personal services, you've got your construction contracts. That's what I deal with a lot. And it just seems like, if we just had one form for each one of those types, it would be great. But when you think about within those categories, you still have a wide variety of things. And a construction contract may be something very small that requires very little, oversight or anything by the owner, the entity. You have others where, you need maybe an owner's rep, and, there's an engineer involved, and there's a lot of things. And so, I've got examples and templates within the templates that I might go to to say like, this project really feels like this kind of thing, and I'll do that. But to Eileen's point, there's certainly no one size fits all, and even within those broad categories. And when we have tried to do sort of the template approach, it just doesn't work because there are so many nuances. And from the efficiency standpoint, I can't say enough, a phone call, 6 minutes is worth, probably 2 weeks of back and forth emails, because just being able to instead of saying, I need this kind of contract, describing to your attorney, this is the deal we're trying to do, this is the kind of contract, this is what we're trying to accomplish. That's going to really narrow the field of like, okay, well, here's an appropriate form that might be a starting point. And I see it all the time where you get what I'll call like a Frankenstein document. It's like clearly people have been passing around a document for years, sometimes decades, of things that have worked, and they just keep building and building, and before you know it, you've got something that's just unworkable and kind of scary to work with. And I don't think that's good for the counterparty either. And you spend a lot of time then going and striking out things that you actually don't need for that particular transaction.
Completely agree with that. One of the benefits, if you're going to work with an attorney, particularly in local government, find someone who's been doing local government law specifically, because I know that people that I know who practice in this area, and I would include Tommy and me both here, is that we've been doing this long enough that whatever it is that you're looking for, we've probably done something similar. So if the concern is that it's going to cost us a whole bunch of money to have our attorney create a new contract for us, in reality, the way we work is we're probably not going to start from scratch. It's probably something we've seen before. It doesn't mean that you're getting a duplicate or a template of somebody else's work, but what we can do for you is create something based on something we've done before, which is fairly efficient, and then the changes from there are often pretty nominal, depending on what you need. So that's a real efficient way to make sure that, if your worry is we don't want to pay a lawyer to write all of our contracts for us, if you have someone with enough experience doing this work, they're going to be able to do it a lot faster and more efficiently than somebody who doesn't practice in this area and hasn't seen this kind of stuff come up before. And I would also echo what Tommy said about, I understand the impulse. I see this with clients who often borrow each other's contracts, or they borrow contracts from the state of Oregon, or they're using some contract that somebody else used for something else. And it often will be multiple pages. And then they'll send it thinking that it's going to save us a lot of time, save a lot of lawyer time, because then it's already done, right? And we're just going to look it over and either say yes or no. But the fact is that as an attorney, you have to go through the entire contract and take out what doesn't belong there, put in what does belong there, modify it however you need to for Oregon law. A lot of times I'll get contracts that were prepared for the federal government, which have a bunch of stuff in it that you guys don't need. So not to belabor the point, but in my experience, the way I like to work, and Tommy can echo whether he works this way or not, is if you have something you want to accomplish, and I think you reference this, Tommy, is send me a note, call me on the phone, tell me what it is you need. We need to go buy a backhoe. How do we do this? And so that steps are going to be, helping you with your public contracting questions, and then helping you create a document or reviewing a document that will work in your situation. That could be way more efficient than thinking that you're going to save attorney time by giving us somebody else's contract.
Yeah, and a similar tool I've used is for some clients that do a lot of contracting is sort of develop like a term sheet, and that's something that's almost like a template where it asks certain questions of like, what's the deal, what's the compensation going to be, who are the parties, and just sort of give the basics. So I would encourage everyone to work with their attorney to have develop those kinds of tools that it's almost like a questionnaire that you can fill out to provide that prompts the even if you don't have time with the call, it can at least prompt the details of what the deal is, so that your attorney can then have a better sense of how to sort of what format to start with.
Kaylee, you popped up. Do you have a question?
Yes, we do have a question. The question is, do contracts that are sent over from other organizations or contractors for us to sign need to be reviewed by our district's attorney?
I can speak to that first, and Tommy, if you can tell me whether you agree or not. Yeah, absolutely. One of the questions that comes up fairly often is you will have a contractor who will propose their form of contract, and in the area of contracts, what the attorneys prefer is use our form and not their form. But sometimes if the contractor has a proposed contract, it might be perfectly fine, but it definitely needs to be reviewed because the contractor's interests and yours are not necessarily the same. So it sometimes works to have the contractor provide their form. I have looked at some that were mostly fine, and I might suggest a couple of minor changes, and that's fairly quick. But I also have gotten some contractors' forms that if you had not asked for my review, you would have ended up with a really potentially dangerous contract. So I always recommend, get at least minimal review. And if you trust your attorney, they'll tell you that this is fine with these minor changes, or, oh my God, don't use this. Here's a better one. My response would be yes. And don't assume that because some other organization has used it successfully that it necessarily is going to work for you. Yeah, that's my take.
Yeah, I'm in a similar place, and I think there's kind of two reasons to get at least some review. One is, in my experience, a lot of the vendors or other contractors, even if they have their standard terms and conditions, they don't include all of the provisions that are required to be in public contracts. So depending on the kind of contract you're dealing with, the statutes say these contracts shall have the following provisions in it, and these private vendors, they don't have that in their own templates and their standard terms and conditions, and so you need to be able to add those in there just to make sure you're in compliance with the procurement code. That can be really easy to do just by having an addendum that says, oh, in addition to their standard terms and conditions, see addendum A, that has the provisions that we know need to be in there. And then I think too, just a quick review it's just issue spotting. It doesn't have to be a negotiation of the contract, but things I see a lot where the contractor has limited their liability, maybe to just the cost of the contract. That may make sense in a lot of situations, and in other situations, it's a huge risk to take on, and they're going to ask for what benefits them, not what benefits you. So if you don't have at least someone who's either a procurement person or your attorney looking for those provisions that create that extra risk, you end up carrying that risk.
Absolutely. Hopefully that answers the question. If the person who asked it didn't get that answered, please let Kaylee know.
Yeah, we do have another question. This one is a little bit long. So, is the general counsel there to help the board be successful or help them get rid of a fellow board member? I've been asking our board for outside counsel to review proposed board policies before adopting and allowing the public to review them. But now I feel like they may be involving counsel to retaliate against me.
Well, that's an interesting question that raises a few issues. I can I can tell, first of all, based on a very recent experience, there's a lot of angst lately around board stuff. To answer the initial question, the general counsel is there to advise the board on how to do its operations legally. You know, our objective is to ensure that whatever the entity is trying to accomplish, that you're able to accomplish it within the confines of the law. So the operational aspects of the entity are always paramount because we recognize you have a job to do. Where your attorney should be advising, if you have an attorney who's trying to advise in any way that is promoting divisiveness in the board, then that's a red flag, because we represent the board collectively, and I can tell you that conflict within the board is prevents you from doing your jobs very well, and B, can set you up for all kinds of problems. So if I'm preparing board policies or documents, they are designed to be ensure that the board can operate effectively within the confines of the law. If you feel like they are designed to discriminate against you or treat you badly, I think there are two thoughts. One is they might just be telling you that you need to sort of be aware of what the law requires and cooperate in the best way you can. But I guess that's as far as I can go with that without giving a lot of unfortunate examples. But so I think your initial question is, what's the role of general counsel? And that's the role of general counsel.
Yeah, I totally agree. I mean, it's these kinds of questions actually that make the work really interesting. But the role of the general counsel is to advise the board, the entity, which operates through the board, but usually either by vote or by consensus. And what that means is sometimes it's 4-1, sometimes it's 3-2, and people can't maybe shape the policies or the resources in the way they want. And that's just a reality of working on a multi-member board. But when it comes to the legal advice, I mean, that is not really a factor. It's more of, are you doing the work? Are you doing it within the confines of the law? And are you following the procedure that you're supposed to follow? And so that's always going to be the lens that I think I look at it through, that other municipal attorneys look at it through. And I can't say enough or support Eileen enough about, if you have an attorney that's actually promoting the divisiveness, that is a red flag, because that we should actually be agnostic to all of that. And, the politics are going to be the politics, but we can help with the procedure and with the substance of the law.
Are there other questions, or was that the end of that one?
That's the end of that one. And then I do have two more questions, it looks like. One goes back to kind of the beginning, talking about using your attorney's time efficiently. The question is, why not have all board members present? That way we avoid the chair filtering the information.
Yeah, let me take that second one first. And I think that is a way to do it, is instead of just identifying the chair, always have the whole board present. That's one way to ensure that all the information is shared with everybody at the same time and in the same way. Just sometimes that's not practical, right? And so that's why it's not wrong to delegate that authority to one person, whether it be the chair or someone else. But I think that question requires the board to discuss amongst themselves what they're most comfortable with. Some boards are not going to be comfortable delegating that authority to the chair or to anyone else, in which case they should choose that route of having everyone at the table all the time. And it's just going to be a case-by-case basis.
I agree. And also the issue is, if you have a majority, a quorum or more of your board in the room, you have a public meeting. So the other issue is, maybe it might be helpful also to explain attorney-client privilege. The board is the client, And the communication from the attorney to the client is privileged, meaning it's confidential. We can't share it with anybody except the client, but the privilege belongs to the client. So if you guys decided to go share what the attorney said, that's your prerogative. It's usually not recommended, but the attorneys, what the work we do for you is confidential. But if you have the entire board there, or even a majority of the board, you're going to have to call a public meeting in order to hear from anybody legally, right? But you have to remember, and then you're like, well, of course, we'll do it in executive session. Well, there is no executive session authority to meet with your lawyer just to meet with your lawyer. It just isn't there. So there are ways to get there, like if you're in litigation, then you can meet with your lawyer in executive session. Or if the attorney is sharing something in writing with the board, then that document can be discussed in executive session. But to just meet with the lawyer in executive session, it doesn't exist. So you would have to do it in open session. And do you want to obtain confidential advice from your lawyer in an open session? You could, but those are the practical ramifications when you're talking about public entities and how to communicate with them. The communication in theory should be going to one of the reasons why I like to communicate with my contacts in writing is that if they decide to share that with the rest of the board, there is executive session authority to do that. But the idea is that the board chair is supposed to be funneling that information to the rest of the board. And if they're not doing that, then that's a conversation the board needs to have collectively, is to figure out how to manage that.
Thank you. All right, our next question. There are different methods of communication, such as phone, email, text, when reaching out to our attorney on a new issue. Most attorneys are busy, so is a scheduled 15-minute phone call the best way to get started to avoid being billed for each email?
Go ahead, Tommy. I have thoughts, but go ahead.
So for me, and this is just for me personally, yes, a scheduled 15-minute phone call, which will probably even take less than that, is super efficient way to do it, because you can convey a lot of information, you can ask a lot of follow-up questions, you can do all the back and forth in a very condensed period of time. And if it goes longer than 15 minutes, it's probably because you need to do that and to have discussion, and it's a more complicated issue than maybe you thought. So the other thing, it just depends on how attorneys work. I know if anyone's email inbox looks like mine, there's hundreds of new emails every day, and so figuring out how to prioritize is always difficult. But scheduling a call makes it very clear what the priority is and what the timing is, and getting someone on the horn to talk to them about it, I think makes a big difference. So maybe it's a little old school, but for me personally, I think it's a very efficient way to get started on anything that's new.
Agree with all of that. First of all, I absolutely hate trying to communicate with clients by text. I think it's some lawyers might be fine with that, and for short, administrative things, I think it's okay. But that's not my preferred way, just because it's hard to say anything substantive in a text. For me, I think it depends on the issue. If the fact is you just had a couple quick questions, can we get you on the horn to talk about some stuff and maybe get some general direction? Those lend themselves very well to phone calls, or prefer Zoom. Zoom seems to have replaced the old-fashioned phone call. That's fine. The other thing I find, though, is that if what you need is for the lawyer to review something, or we have some documents we have questions about, I would prefer to have you just send those to me, let me look at it, and then we can schedule a phone call to talk about it after that. You can do it the opposite way as well. But if it's a matter of, I need you to review this so we can talk about it, I'd rather get the documents ahead of time rather than you calling me to tell me you're sending me documents or you emailing me to say that you're going to be calling me. It would be more efficient to pick one or the other, but I think it really depends on what it is that you need. So you can kind of have to work that out, I think, with the specific lawyer. But in terms of efficiency, what I find can be a little I'll get an email asking for a phone conference, and then a voicemail following up asking me if I got the email. So I guess part of this is kind of barely related, but one of the things I was dealing with today is recognize your attorney might be busy, and if you don't hear from them within, a day or two, then maybe follow up. But if you sent something at 9 o'clock this morning, you don't have to follow up at noon and find out whether, what they have to say about it. So that's just my very self-serving response, given what's been going on lately.
Wonderful. And we did get another question. What is the best way to work with your attorney on policy development and adoption from the board?
Yeah, I can start with that. I think for me, I think it's important to involve your attorney with policy development. There's so many times where you think you're just addressing one thing and it invokes other areas. So if nothing else, kind of what I talked about earlier, like issue spotting is really important. I've seen draft policies come, before a board, and you look at it at the last minute, you're like, oh, well, this just, there's a different way that this probably should have been done, or, it's crossing with some other policies or some other laws. And so I think just a little bit of time on the front end to say, look, we're adopting a new policy. This is why we're doing it. Alerting to your attorney to the fact that you are doing it will probably tell you right away if you need further review or not. And again, asking those questions on the front end, a very quick phone call, a very quick email that just says we're doing this, it can save a lot of back and forth later, or worst case scenario, sending them the policy that was adopted and then finding out that, something is wrong with it. So I'm always, the theme of a lot of my urging to my clients is that an ounce of prevention is worth the pound of cure. And I think that goes for policy adoption as much as anything else.
Yeah, agreed. And there's some policies that are kind of required by law, so everybody should have one, like public contracting rules and public records policies. So if it's kind of a standardized policy, that's another one of those things that we have very likely done something like it before. So maybe starting with the lawyer might be more efficient than borrowing somebody else's. But I completely agree that before it's adopted, at least let your attorney look at it. I mean, I have seen some policies that seemed like a really good idea for the board, but they're actually illegal, like policies that say that if you miss a certain number of meetings, we're going to kick you off the board. That's not an illegal policy in most cases. So I would say in terms of policy, I completely agree that your attorney is going to be able to tell you this is fine, or there might be a better way to go about this. Sometimes, given, if you have an experienced lawyer, you have learned from other people's mistakes and might suggest that you go about it in a slightly different way. But yeah, I as you can see, Tommy and I are both probably going to say, yeah, well, when in doubt, share it with your lawyer, and we'll tell you if you need more or not. But again, that 15-minute phone call or email can save you a world of hurt than trying to fix something after the fact.
Wonderful. And another question came in. What guidance do you have on whether general counsel needs to review grant applications and letters of support before submission as part of a grant application process? Note, in this scenario, no contract and no award has been given yet.
So to me, this is a shade of kind of what we were just talking about, right? And in my practice, I don't want to be a gatekeeper. I don't want to be the one that says, like, I've got to review everything that goes out externally. That's just not the case. So I think the answer to this question, a lot depends on, your entity and the sophistication of your own entity. If you're doing grants and that kind of, and grant awards and contracts all the time, you're going to have a better sense. If you've never gotten a grant before and, you're trying to piece everything together, you might, I would caution you to do that without any help, even if it's just a cursory review from your attorney. So, there's going to be 100 different versions in between those two scenarios too. So I think the first thing is always to do a gut check, which is, have we done this before? Do we know what we're doing? Because if we haven't done it before, we don't really know what we're doing. Why not call your attorney and just ask, like, hey, do you see any issues here? What should we look at more? And if your answer is, we do this all the time, you may not get much value from talking to us. So it's there's a lot of factors there, but I would, sort of do the self-reflection first and then figure out how deep, it really makes sense to engage.
Yeah, I in my experience, this kind of opens up a larger topic that we can touch on as well. And there are times when, I guess the initial question is what is it that you need from the lawyer? If the granting agency usually has some pretty specific stuff that they want you to do, and a lot of it has to do with explaining what you intend to do with the money, how this all works, et cetera. So if they have given you instructions and you're responding to the instructions, there's really not a legal component to speak of in there. You read what the grant is supposed to say. You guys know better than we do how you would be using the grant money. And it's going to be up to the grant making agency to monitor and make sure that you're doing it correctly. So in specifically if it's just a grant, you're going to be applying for a grant, I would say that's kind of an internal function, at least the applying for and getting the grant. What you do with the money after that may invoke public contracting issues or things that maybe the attorney needs to get involved with. But I would see, for the most part, that whole grant making process is kind of a staff function or someone that you're hiring to write the grant for you, because the requirements for what the grant making agency are looking for are usually pretty specific. So you don't need a lawyer to interpret those for you. But again, once you get the money, there may be some questions that come up about, can we, is it okay to spend the money in this way? Maybe the lawyer could get involved then. And it also raises an issue I know Tommy and I talked about when we confabbed before we had this, was there are certain things that, in my experience, are basically staff functions that you might not want to be having your lawyer do all the time for you. Like sometimes, for those who are getting ongoing training, bless you, because things like responding to public records requests is part of your job. And there might be something tricky about it that you need to sort of get legal advice on, but asking your lawyer to respond to all your public records requests is probably not the best use of your lawyer's time, unless it's particularly complicated or concerning. And now we have the issue with, which we're encountering, is the ability for just anybody to file a public meetings grievance. They're alleging all kinds of wrongdoing at your meetings. So far, in my experience, very few of them are filed in good faith. They're coming from somebody who just wants to play gotcha with the board. And at least initially, what I've found with my clients is I'm like, I'll help you write the first couple. But if you're asking your lawyer to respond every time somebody's complaining about your public meetings, you could do that, but I think it's going to get expensive really quickly. So I think it's always a good question to ask, is there a legal component here? Do we need a lawyer's input on this? Or are you looking just for, do you just kind of want to talk through it with the lawyer? But there are things that are kind of fall within the purview of operations that really are kind of operational things that you may not need your lawyer to help you with. And I would put grant processes in that category. If you have a question that rises to the level of needing legal advice or interpretation, then yeah, but if it's just kind of an operational function, I don't think you necessarily need to involve the lawyer, but I guess you could.
Wonderful. We do have one more here. It says, I have some serious concerns about some board policies that our board has adopted, restricting social media use, allowing districts to monitor social media use, and restricting the board member from speaking to the newspaper, as well as having language allowing the board to terminate another board member. I just want to know if this is something that is legal and is not violating state laws, and if there's anything I can do at this point after the fact.
And
then you want to go first? I went first last time.
Sure. We're probably going to say more or less the same things on this. So what I'm reading from that is a particular board member or multiple board members are feeling kind of policed by the rest of the board, or feel like your ability to act as a board member are being restricted. And that's a very fact-based thing that I can't get involved in, who's right in that situation. But if there are some things that board policies, a good board conduct policy. I'm not a huge believer in bylaws. I don't think special districts in particular need them, but an equivalent might be a board policy that talks about how the board will conduct itself during meetings and so on. Those don't rise to the level of law. They're policy, and the board is supposed to follow its policies. My experience, for example, with bylaws is clients who just use them as one other thing to fight about, like, you violated the bylaws. No, you violated the bylaws. But with that said, there are certain policies that the board needs to understand it does not have the authority to adopt. The question referenced specifically, telling a board member that they can be booted off the board is probably not legal. I'd have to look at the policy to see what exactly it says, but probably that's not okay. The other issue that seems to come up a lot lately is board members insisting that their freedom of speech is being impinged upon because they're saying negative things on social media, or they're saying negative things about other board members in public, or so on, and the board would like them to not do that. That's a policy thing. The benefit of policies is if the board is intending to pull in the same direction, policies can establish some ground rules in terms of what we expect from each other. But you can't, by policy, necessarily regulate conduct of board members. It's a kind of a tricky business. I've seen some policies that try that are blatantly wrong, and some sort of well-intended policies that certain board members just decide are overly oppressive. So I'm not sure I can get it. I feel like I'm blathering a little bit on that one, because it really depends on the policy and what it is that it says. And the question is, does your general counsel need to get involved in that? I think if it's creating conflict, for sure, at least get a take on, is this policy problematic on its face, or is it problematic in the implementation? And maybe the first one is kind of a legal question. The second one is really sort of a board management question. And to some extent, the lawyer can help you with that. But yeah.
So I think I have similar thoughts in the same vein, but maybe a slightly different take, because I think the bylaws, at least for some of the entities I work with, I think they do work, and only because they set expectations, and their expectations for how people are going to work with each other. But that does come with the caveat that the enforceability of them, when it comes to like the board, there's not much enforcement you can do. I mean, you can, maybe add in that there's, public reprimands or something like that. But, ultimately, whether a board member can be on the board is going to be a question for the electorate to decide. And there's a recall option, but short of that, there's not much hammer you can swing for forcing someone to follow these policies. So again, I think it comes down to the tenor of the entity and how that particular board at any one time wants to work together. I always tell my boards that, even if you adopt these policies, you should review this often. And when you have new people come on board, they should be part of it too, and see if it's still what you want to do. It's not law. It doesn't mean once you establish these governance policies that every future board has to follow that. And it's supposed to be a relationship kind of building thing. And I think most problems are people problems. And so it turns out to be a good tool, and it's a tool you can put into place again when things are quiet and not in times of crisis, because then you end up with policies that are addressing, two individuals as opposed to addressing what the entity really would benefit from.
Agreed.
Right.
Okay.
Well, if there's no questions, should we turn to some of the nuts and bolts in our last few minutes here of
Go for it.
I have a couple little things. I just, I don't speak for all municipal special district attorneys. This is just sort of me, but things that I think that make working more efficiently and is, it always depends on the question you ask is going to drive the answer that you get. So there's little things like, if you get a contract and, client says, please review, right? Well, please review is not very helpful because we have no idea what that means. Do you want to review it for legal sufficiency? Do you want to review it for a particular question? Did you have concerns about it? So I think this goes back to that, whether you send it before or after the phone call saying, we would like you to review this because, and then part and parcel to that is providing all the documentation. If you just, clip out a snippet of a contract and put it in an email and say, does this look okay? Sure, in isolation, but what does the rest of the contract say? Are there's some defined terms in here, or I don't know what this contract is even purchasing. So yeah, the words on the page look fine, but the meaning could be totally different if you haven't really shared all the information. So just a couple more things on kind of my short list. The drafting of documents and contracts or whatever it is, that happens usually with the attorney, and then they go back to the client and we don't know if it got signed, we don't know if it got changed. So my pitch is always, if you've had your attorney work on draft documents, send them the final version. Most likely there's going to be questions about it in the future, and then you're going to save a lot of time by having me or someone like me go through my emails and be like, oh, is this the final version? I don't know. I certainly don't want to compare this signed version with the last draft that I sent. So just always get in the habit of sending back the final version. It's also a great great resource because you may not be able to find them later either. And asking your attorney that they're there. And then just it's always, I think, important to identify the source of the document that you are sending to your attorney to review. It makes a difference knowing if this came from, the counterparty. Oh yeah, these are their standard terms and conditions. It's good to know if you've used it before. It's good to know where you got it when you used it before. Oh, this came from a similar agreement we did with the same counterparty. And then the one I'm getting more and more concerned about is not knowing that something was generated by AI, because AI still is very flawed. It still has, what they call hallucinations, and you will get things from AI that are factual. You will get things that look like they're right and standard, or criteria, and they're just made up. And when you get that, it looks just close enough to be like, well, this is what someone meant this when they wrote it. And then when you find out that AI wrote it, it does cause you to question everything. And then you see it in a different light, and it's like, oh, like now I'm more confident this is actually just made up. And so, it helps us to know what the source is, regardless of what the source is. But I can tell you, it will create a lot less work in the long run, just sort of really knowing that data point.
Agree with all of that. The point about making sure that, and I completely agree with Tommy in the sense that sometimes I will prepare a document, a draft of something, and I'll say, here's my proposed policy. Let me know if you have questions. And it leaves my hands, and then I might not see it again ever until 3 years later when somebody calls and says, how should we interpret this policy? Or and I'll go back and I'll say, well, assuming that it didn't get changed from how I wrote it, then I would do this. But a lot of times I'll have to say, can you send me the signed version of that as well, whether it's a contract or a policy or something like that. So I agree that if you remember to do it, make sure that your attorney has the final version of what was adopted, because otherwise we just have to go with how it looked when it left our hands. And the concern is that it leaves our hands and then somebody decides it needs to be changed and we never saw those changes or can vouch for them. I think I would put also in that, just because it just occurred to me, and this is no shade intended on SDAO, but what I know that SDAO has a bank of documents. And sometimes I'll have clients who say, oh, I got this policy from SDAO. And sometimes I'll look at it and I'll think, okay, it's there because somebody sent it there, but it's never been legally vetted. It's never been legally reviewed. Somebody wrote it at some point with the best of intentions, but it's never been reviewed legally. So I think never assume that the document that you're receiving from anywhere is legally sufficient. Give your attorney an opportunity to look at it and tell you whether it is or not. So that was just a little side nugget that occurred to me, kind of in the area of the contract and the context. Yeah, I don't know that I have anything to add to that. Anybody have any questions on that one? The other issue that we talked about that kind of very important in our experience is it is incumbent upon the board. The staff have the staff stuff, but the board, there's some basic stuff where when boards get training for this is very good and important. But the ins and outs of public meetings law are your responsibility to know as a board. And the stakes have gotten increasingly higher, as I mentioned earlier. It's now an ethics violation to violate public meetings law, and there is a tool that is now being weaponized pretty intensively, in my experience, of people who are just coming at you with all kinds of accusations. And what I find is the best advice I can give boards is understand what the law requires you to do. And because you are, as of now, you have 21 days to respond to a complaint about public meetings violations. You have to respond within 21 days, and then your response and the original complaint are required to be filed with the Ethics Commission, who may or may not do an investigation depending on, what it says. Those responses, depending on what they're accusing you of, can take a lot of time. I've done some for my clients that are kind of like mini legal briefs, because the people are rattling off all kinds of statutory citations that you may not know anything about. But if you have made it a priority to understand what the public meetings law does require you to do and what it doesn't require you to do, then you should be able to get to the point where those responses are pretty rote. You will know if they're right or if they're not. And if they're not right, then basically it's a paragraph saying none of this is true. So little current, based on current events, strong reminder to make sure that your board understands what public meetings laws require you to do and what they don't. It also is a way to empower the board to protect you from people who are coming in and trying to take over your board meetings and telling you how they're supposed to be run. If you don't know any better, then they are very disruptive. If you do know better, then they are just noise, and you can treat them that way. We would say then the same would be true also about the ethics laws in general. Public meetings laws are now ethics violations. Tommy, do you want to speak to this, because it might be helpful in terms of the general counsel's role when it comes to ethics laws?
Yeah, it's an interesting intersection, because by and large, the ethics rules apply to the public official as an individual. And so, with some exceptions, you can't even rely on the advice of counsel. There's some, I think, where it would lessen the penalty or affect whether or not there was a violation. But they really are personal in nature. And so this gets all the way back to the beginning of like, well, who is the client? And for the most part, the general counsel is there to advise the board as an entity and not the individuals. So I've even heard, some presentations from people involved with the Ethics Commission that, even just the mere seeking out of the ethics advice from the entity's attorney, from the general counsel, would itself potentially be a violation because you'd be using your public office for private gain because you're essentially getting private advice on the public's dime. Now, I think they've softened that a little bit. I've heard them, it doesn't mean that the general counsel can't provide an overview, but you certainly can't, should not be asking the general counsel for specific ethics advice because it really is personal in nature. And so I think there's even been some statutory changes about even being able to vote as a board to allow that advice to occur. This is an area that's, I think, in flux, and the ethics commission is going to have to grapple with exactly the ins and outs of this. But all of this is to say, be very deliberate and cautious about the advice you're seeking, because if you ask me about ethics stuff, I will be very clear that I'm giving you an overview. I'm not advising you personally. And your attorney may or may not do that, but you need to know that they really should not be advising you personally. So it makes for, there's some risk there, but as long as you're careful and understand the ins and outs, I think you can navigate it pretty well.
Agree with that one.
And then just in this sort of the last point I would make is just about being informed about the laws and stuff. I mean, it's a little bit easier now that the trainings are required, but I would, they're only required once during a board member's term. I would encourage board members to do it regularly, make use of SDAO's trainings, and just stay up to speed, because things do change. And the more well-versed you can be in it, the smarter the questions are that you ask, and the easier it is to respond. And I think it just makes the whole thing more efficient.
Is there any other questions in the audience that we can address?
It doesn't look like we have anything else right now. So, yeah.
That was good. That was a tidy hour.
I appreciate all the questions. Those are good. And so I thank you for everyone for their engagement.
Yeah, thank you. And if those of you in the audience, if this was beneficial, please let Kaylee know. It's the kind of thing we talk about doing now and then. And if it was helpful for you, then, maybe it's something that could be done semi-regularly.
Yeah.
Thanks, everybody.
All right. Well, thank you everyone for joining, and thank you, Eileen and Tommy, for putting this on. I think it was really helpful, and I learned lots. So thank you again. And with that, everyone have a wonderful afternoon.
Thanks you. Thank Tommy. Talk to you later.
Yeah. Goodbye.
Bye.